Hello, everybody, and welcome to episode 4 of Washington Probate TV. I'm your host, Christopher Small, and this is the internet's most passionate show about probate. You know, I always feel funny saying that. This is only my 4th show. I'm sure I'll get used to it over time. But there are a lot of probate's a tough subject, and a lot of people have to go through it. So this show is just really dedicated to helping you get your probate questions answered, obviously giving you an outlet to get some help if you need some, and otherwise just sort of talking probate and trying to sort of minimize the fear, trying to make it easy, right? Pain-free probate is what we're trying to do here. So welcome, thank you for listening. Let's just stop beating around the bush and just get right into the content for today, right? Today, I want to talk about disclaimers. So I've got a client that is going to do a disclaimer for their estate, and I thought it'd be a good time to sort of talk about what that is and how it works and why you might want to do that. So to start at the beginning, a disclaimer is basically a document that you file if you are the heir to an asset. Okay, so let's say that your relative of yours passed away and they wanted to give you a house, okay? And for whatever reason, you didn't want the house. Maybe there are some tax consequences that go with it. Maybe you don't like the house. I don't know. Maybe you just don't want the house. Maybe you don't feel like you deserve the house. Whatever. For whatever reason, you decide that you don't want the house, and you are okay with knowing that the next person to get the house is going to be the person that you want to get the house, right? At least it works for you. And you'll see why that's important here in a minute. You can file what's called a disclaimer. A disclaimer basically tells the court and the world that you want to be treated as if you died before the decedent. Okay? Now, it's important to note as well that you can disclaim your entire inheritance, or you can disclaim as to specific things that you could be getting. So for example, if you were getting a house in $100,000 and you didn't want the house, you could disclaim specifically on the house, still take the $100,000. Okay? Just to be clear on that. Now, it's also important to know that if you are going to disclaim, it needs to be done within 9 months of the date of death of the decedent. Okay? So if you're going to disclaim, this needs to be filed before that time. It's just a rule. Okay? There's a bunch of rules in probate, a bunch of timelines to remember. This is one of them. All right? Now, the downside to the disclaimer, if you thought that this might be an option, is that you don't get to pick where the asset goes. Okay? You are out. You are just considered to have died before the decedent when it comes to this specific asset. So you're gone. Okay? What they do now is look first. If you have a will, they look to the will and see what happens. Like it could say, my house at 123 Broad Street goes to Julie, and if Julie is not around, then it goes to Fred, and if Fred is not around, then it goes to Bill, and if Bill is not around, then it goes to the residuary of my estate. Okay? That means if you disclaim, then it's going to go to Fred first, and if Fred's dead, then it's going to go to Bill, and if Bill's dead, then it's going to go to the residuary. And the residuary is typically where you say, like, I'm giving all the rest, everything that's left over to blankety blank. Okay? So if you're going to disclaim and you have the option to see where everything is going and you care, then that's where you want to look. If there is no will and you disclaim, typically, well, not typically, but this is exactly what will happen, you will look to the intestate rules to see where it goes, right? And that means you will look to see who the other heirs are, and then you'll look to the rules to see how everything is supposed to be passed down. In the example that I'm talking about, it was pretty simple and straightforward. There was one heir, right? One child of the decedent that existed at all. Okay, so this person is getting everything, no matter what, right? That's how it flows. Just no spouses or anything. It goes to her. And then she had a kid. Okay, now if she is deemed to have predeceased her parent, then everything would have passed down to the grandchild. So she knew straight away, if I disclaim, everything's just going to pass right down to my son, and I'm good with that. So that's what they did. But it's important to know and to think about these things, and to make sure if you want to disclaim that you do it within the time period allotted to make sure that happens. Now, let's talk about one of the main reasons why someone might want to disclaim is that their estate is very large and they don't want to add that asset into their estate for whatever reason. That's a common scenario. They are more comfortable, or they are comfortable with it getting passed down to someone else that doesn't have maybe that estate tax liability already in front of them, to allow them to sort of use the property or use the money or use whatever in the best way possible. That's often a reason that disclaimer is done. There are a bunch of different scenarios where it can happen, and most of them get pretty complicated pretty fast, so I'm not going to really speak to that. But just know if there's an asset that you do not want, for whatever reason, there is a process for making sure that it's not given to you, and it's called a disclaimer. All right, that is it for this episode of Probate TV. Hope you enjoyed it. If you have questions or comments, please leave them below. You can always email me to chris@cmslawfirm.com. And if you need help with a probate, or you have questions, or you want to hire an attorney, I would love to help you. That's one of the reasons why I'm here. Again, you can email, you can call. I think I left my phone number, 206-659-1512. I'd love to talk to you and see if we're a good fit, and see if we can help you out. All right, so until next time,